Ready, start. The High Court accepted their claims, holding them entitled to get the benefit of post retirement dues, including pension from the date of their retirement, treating their service to have been extended to the age of 60 years. Full stop. It is this order dated 18/5/2016 passed by the High Court which is under challenge before this court. Full stop. Learned Senior Counsel for the appellant has assailed the judgment primarily on the ground that the respondents have approached the court after gross delay and that too after the judgment was passed by this court, claiming parity with the said judgment. Full stop. A distinction is also sought to be pleaded on the basis that in Vinod Kumar Goyal case, the said employee had been allocated to the state of Uttarakhand, which was carved out of the state of Uttar Pradesh within bracket appellant bracket close in the year 2000, whereas the respondents continued with state of Uttar Pradesh. Full stop. Council has also pressed into service the principle of estoppel, acquiescence and waiver, as according to the appellant they have already taken the benefit and advantage of the contributory provident fund, having withdrawn the dues after their retirement, and therefore, they cannot now be permitted to claim pension. Full stop. Learned Counsel further submitted that the respondents were temporary employees working under the scheme and therefore would not be entitled to the benefit of pensionary benefits unless specifically held entitled to by the competent authority. Full stop. What has been asserted is that the distinction has to be drawn between the temporary and the regular employees. Full stop. They cannot be held entitled to the same benefits as regular government employees since the respondents were working under the scheme. Full stop. He has prayed for setting aside the order impugned and dismissal of the writ petition preferred by the respondents. Full stop. On the other hand, learned senior counsel for the respondents has supported the judgment passed by the Honorable High Court, asserting that the case of the respondents has rightly been held to be covered by the ratio of the judgment in Vinod Kumar Goyal's case. Full stop. He thus contends that once the rules applicable to the cane development department have been made applicable to the employees under the scheme, they would be entitled to the same benefits provided they fulfill the requirements laid down thereunder. Full stop. Referring to the documents appended along with the special leave petition, he has asserted that a conscious positive decision had been taken by the government to grant the benefits based on a proposal slash recommendation of the Kane Commissioner White later dated 29/9/1997, qualifying it as limited to the extent of financial expenses being borne by internal sources. Full stop. Emphasis has also been placed upon the decision dated 12/11/1997, whereby the employees under the scheme were to be covered by the service rules, government orders, regulations and bylaws as applicable to the cane development department. Full stop. Once the said rules had been made applicable and a conscious decision had been taken by the government wide communication slash decision dated 29/9/1997 with regard to the grant of all the benefits, the subsequent decision dated 13/11/2002 of the Sugarcane Commissioner would not sustain. Full stop. Senior counsel has, with reference to the delay in approaching the court, asserted that the date of retirement of the respondents may not be relevant as pension is a recurring benefit to which an employee is entitled every month, full stop. The claim would not extinguish merely because of the lapse of time, full stop. Referring to the chart appended along with the appeal here, comma, the council asserts that there has been no inordinate delay on their part, full stop. Referring to the impugned judgment, comma, he has pointed out that the High Court has itself mentioned that some of the petitioners had earlier approached the court challenging the notice for their retirement at the age of 58 years by filing writ petitions wherein, comma, in the light of interim orders, comma, they were allowed to continue in service till they attained the age of 60 years, full stop. It has also been pointed out that the state government wide notification dated 28/11/2001 amended Rule 56 of the Uttar Pradesh Fundamental Rules, comma, enhancing the age of superannuation from 58 to 60 years, full stop. With these rules having been made applicable by the appellants and as held by this court in Vinod Kumar Goyal's case, within bracket supra bracket close, comma, respondents would be entitled to the said benefit, comma, which has been rightly granted to them, full stop. In light of the above, comma, he prays for dismissal of the appeal, full stop. Having considered the submissions made by the learned senior counsel for the parties, comma, we find ourselves in agreement with the principles which form the basis of the judgment of the High Court, full stop. The facts, comma, as narrated above, comma, make things amply clear, full stop.